Hello, I am Reiner Fuellmich and I am an attorney practicing law both in Germany and in California. For more than 26 years, I have been active primarily as a consumer protection trial lawyer. I want to tell you about the possibility of filing a class action case against those who are responsible for the corona scandal, which has plunged large parts of the world into chaos, but oddly enough, not, for example, India, Africa, or here in Europe, the country of Sweden. As one of 4 members of the German Corona Investigation Committee, I've been listening to medical, legal, economic, and other experts from all over the world answering our questions about how dangerous is the allegedly new strain of the coronavirus really? How reliable are the PCR tests, which are the basis for almost all those anti-corona measures? And what damage do the measures do to public and individual health and to the economy? And here's the result. There can be no legal doubt that every person or company who or which suffered damages like loss of income because of the lockdown is entitled to full recovery of such damages. Responsible are not only the so-called officials or the government, but also and primarily the manufacturers and sellers of the PCR tests. This is because the political lockdown decision is almost entirely based on those tests, which, contrary to official assurances, are completely unsuitable for detecting an infection. Contrary to official assurances, they are completely unsuitable for detecting an infection. The PCR test is, in fact, not even licensed or approved for diagnostic purposes. For 2 reasons, it is extremely urgent both to terminate all anti-corona measures immediately and to recover damages as quickly as possible. Firstly, there is no factual, let alone a valid legal basis for these measures, including the face masks. And secondly, because of the measures, not because of the coronavirus, the biggest wave of bankruptcies of all times threatens the world's economy right now. And this will particularly affect medium-sized companies, small businesses, and the self-employed, which here in Germany comprise the backbone of the German economy and which is responsible for 65% of all jobs here in Germany. However, as we here in Germany know from years of court experience in cases with so-called structural imbalances, that means small companies, investors, consumers suing fraudulent corporations such as Deutsche Bank, VW, and most recently Wirecard. Because of the experience here in Germany, we know that the German judiciary lacks the necessary political independence to apply the law to such politically and economically powerful players. For this reason, a regional court here in Germany has just made headlines in the news when it referred a diesel fraud case against VW to the European Court of Justice, asking the court to confirm that the German judiciary lacks the political independence to decide such legal disputes correctly and without prejudice. In this situation, a real US-style class action can help. This is how it works in the United States. If a large number of persons or enterprises suffer the same type of damage, for example, monetary damage due to loss of income, because of the same conduct or infringement, the lockdown, a court of law may permit the resulting cases to be tried in a class action suit. The court will then publish this, typically in the generally accessible print media, if necessary also internationally, so that each individual who suffered such damage can decide whether or not he or she wants to join the class, that is, the plaintiff group. The advantage of the class action is that only one single complaint is filed, namely by a typical representative of the class. This is cheaper and usually faster than filing hundreds of thousands or more individual lawsuits, and it is less burdensome on the court system. Also, it avoids contradictory judgments. Most importantly, the applicable US law of evidence, the so-called discovery, helps tremendously. This requires that all evidence relevant for deciding the legal dispute must be produced and put on the court's table. In contrast, in contrast to German lawsuits, that is, with structural imbalance, the ones that I just talked about, the withholding or even destruction of evidence does not remain without consequences in a US court of law. Unlike it is the legal practice here in Germany, a party withholding or even destroying evidence may easily lose the case because the court may enter a default judgment against that party. In the US, that is, not here in Germany. How this works in practice is perhaps best explained through a case in which I represented a German woman many years ago. My client suffered serious damages because of defective silicone breast implants. She underwent breast reconstruction after cancer treatment. Breast implants made by Dow Corning were used for this. These implants were defective because they leaked and caused severe damage not only to my client, but also to the child she was pregnant with. Of course, my client was not the only injured party. Therefore, because there were 170,000 of such injured people, the court allowed a class action and informed all potential claimants about this class action case worldwide through publications in the generally accessible media. That is how my client learned of the class action, contacted me, and I helped her assert her claim for damages. Since the German PCR test, first pushed by Professor Drosten of the Charité Hospital in Berlin and produced and marketed by a German company by the name of Tippmol-Biol, was, on the recommendation of the World Health Organization, also one of the first tests to be marketed worldwide, including in the US. The US courts have jurisdiction for a class action to be filed against Drosten, Charité, Tippmol-Biol, and the World Health Organization. If such a class action then leads to a decision in favor of the representative plaintiff and the judgment becomes final, then this judgment is binding for the defendants with respect to every other member of the class too. Now, our Corona Committee's primary political goal is to start the long overdue public scientific discussion about, among other things, the true danger of the virus, the reliability of the tests, and above all, the collateral damage caused by the anti-corona measures, both from a health and economic point of view. And this political goal will be reached faster, we believe, if a very loud bang ends the current stampede of panic and confusion. And that is, in fact, the political purpose of this class action. If hundreds of thousands or even millions of people decide to go to court over this, this sends a signal that will, I believe, interrupt and stop the stampede and will make this badly needed public scientific discussion possible. So the higher the price tag of the damage claims, the louder this bang becomes. By the way, making the victims of the anti-corona measures whole is not only legally possible, but it also makes very clear sense economically. And that is because if we don't reimburse those small and medium-sized corporations and the self-employed for the damages they suffered, and they then all file for bankruptcy, this would trigger enormous tax losses, but also enormous social transfer payments for, among other things, long-term unemployment payments. And that would, in any case, be much more expensive than to compensate the injured parties now and to immediately end the measures so that those injured parties have a fair chance of restarting their businesses. Thank you.